Well, good morning, everyone, and thanks to Ciara and the team for hosting this morning. Today, I'm going to talk about some emerging case law from the European Court of Human Rights. And in the last 12 months, there's been a number of significant Grand Chamber cases which have relevance to the situation of refugees and asylum seekers. These cases are central to my ongoing PhD research, which considers the role of international law in preventing and tackling trafficking among refugees and asylum seekers. But I think they have relevance beyond this to the asylum context as a whole, and that's really what I want to briefly touch on today. Looking about some of what's been written and said about these cases, and really looking for elements of promise in the midst of what could be described as peril, and really what could be described as a bit of a restrictive trend in the court's case law. Before we go straight to the cases, I do think it's worth paying attention to the growing need to have a consideration of international human rights law to the fore in discussions on the protection of refugees and asylum seekers. Why are we talking about international human rights law? Well, one author, Vincent Chitaï, has actually gone as far as to argue that the normative frame of forced migration has been displaced from refugee law to human rights law. And while not everyone may agree with him, this idea that human rights law is now the main normative frame of protection for refugees and asylum seekers, with refugee law being subsidiary, maybe not everyone will agree with that, but I think the fact that he can make such an assertion shows the growing importance of human rights law in the realm of refugees and asylum seekers. And one of the places where that is evident is when we look at the case law of the European Court of Human Rights, a court which has made quite a lot of developments and progress for rights for refugees and asylum seekers. And I think any talk of a restrictive trend needs to be critically analysed in that context. Before we turn right to the cases, I just want to draw your attention to what exactly we're talking about when we talk about the asylum context. This slide that I've shown is really just the broad strokes of the process. Obviously, everybody's journey is different and very nuanced, but this is the broad strokes, just to highlight the fact that really we're not just talking about crossing a border, but there's a number of stages in the process, and there are protection needs along all stages of those processes. My research engages with vulnerability and risk of trafficking along those stages, and it has shown that really that risk persists throughout all stages, and indeed other protection needs persist throughout all these stages. And decisions of human rights bodies and courts could work out in practice in ways which might mitigate those risks, but also in ways which might aggravate the risks. And so with this in mind, let's turn to a brief summary of the three cases. For any of you in the seminar who are familiar with these cases, you'll be aware that they have faced criticism. Thomas Gammeltoft Hansen, speaking about these three cases that we're going to look at today, asserts that this trio of Grand Chamber judgments points to a new and more cautious direction of the court in regard to migration-related rights under the Convention. And so with that in mind, let's turn to the first case, which is Iliac and Ahmed versus Hungary. This judgment was handed down by the Grand Chamber in November 2019. Very briefly, the facts: two Bangladeshi nationals arrived at the transit zone in Hungary from Serbia. Their asylum claims were refused on the same day. They were held for 23 days in the transit zone while their appeals were going through, and they left to Serbia after that. They alleged a number of violations, including on Article 3 regarding their removal, Article 3, of course, the prohibition of inhuman and degrading treatment. Also Article 3 in relation to the conditions in the transit zone, and Article 5, which is probably where this case attracted most attention, was on their deprivation of liberty. So what did the court decide? Well, on their removal to Serbia, the court held a violation of a procedural obligation under Article 3. The court spoke at length of a duty to ensure that the third country is safe, referring to this absolute nature of the prohibition of ill treatment. And in particular, the court pointed to the fact that it didn't appear that the Hungarian authorities had taken sufficient account of consistent general information at the relevant time. This included reports from UNHCR and other information. And because of that, there was held to be a violation. And I think this really demonstrates an aspect of promise, that actually the Article 3 and the number of obligations, including these procedural obligations, all have to be complied with under the Convention, which I think results in greater protection. The story wasn't the same for the conditions in the transit zone. It was held that there was no violation, and that was because the court held that the conditions did not meet the minimum level of severity to amount to an Article 3 violation. Now, we don't have time to discuss in detail about that today, but I do think we should pose the question, having seen some of the images coming out of these transit zones, as to what precisely would amount to a minimum level of severity in these cases. As I said, Article 5, the holding on Article 5 was perhaps the most controversial and most written about, and that was because the court held that the stay in the transit zone did not fall within the material scope of Article 5, meaning that the court didn't hold that it was in fact a deprivation of liberty to check if there's a violation. One of the key factors, among others, was the fact that the court assessed that the individuals were not permitted to leave in the direction of Hungary, but were free to leave in the other direction. It's controversial for a number of reasons, because, you know, how free really were they to leave in the other direction? What would await them on the other side? It has been widely criticised, this aspect of the judgment, and it is worth noting that a Court of Justice of the European Union decision in 2020, which assessed the case of two others who were in that same transit zone, albeit for much longer, held that it did amount to unlawful detention, and that transit zone is now closed. So already we can see elements of promise, but also concerning elements from this case. If we turn to the second case, ND and NT versus Spain, this judgment was handed down in the 13th of February 2020, and the issue was on the highly contentious so-called hot returns from Spain to Morocco. The claim was brought by two men of a group of 600 who attempted to cross the border fence at Melilla. They were helped down by Spanish border guards, immediately returned to Morocco, and they alleged that there was no ID procedures, no chance to make a claim, and among other things, they alleged a violation of Article 4, Protocol 4, which many of you will know is a prohibition on collective expulsion. Now, again, this judgment has been highly criticised, but I think one promising aspect is actually the holding on jurisdiction and the court's affirmation that although jurisdiction is primarily territorial and that it can be limited, this is really only in exceptional circumstances. And so, key paragraph from the judgment was the court saying that the convention cannot be selectively restricted to only parts of the territory of the state by means of an artificial reduction in scope of its territorial jurisdiction. I think that's really important and really encouraging that the court has affirmed that, especially in a context where these transit zones, sort of legal fictions, are coming through, that actually know the convention does apply throughout the whole of the state's territory, and really has to be very exceptional for anything else to be the case. Having said that, this substantive part is more discouraging. On collective expulsion, it was held that there was no violation. In essence, while the court admitted that it sort of fell within the scope, and in a sense it was a collective expulsion, there was an exception to this violation and a justification in the sense that because the individuals had entered illegally, they talked about this own culpable conduct test, and also the fact that there were genuine and effective means for legal entry. Now, these means for legal entry and their accessibility to the applicants is contested, but that was the holding. As I say, highly contentious, and a number of sort of reports about this case are framed in the idea that hot returns have now been permitted by the court. I think that's not true, and I think we need to keep that in mind. One commentator, Konstantin Kruska, has actually really highlighted this, that to conclude from this that the practice of hot returns was approved is understandable in view of the press statement, but it's wrong. The practice of hot returns was and remains illegal, and I think we need to keep that in mind in the discourse, that we're talking about a restriction, a sort of exception to Article 4, Protocol 4, but Article 3 and also this collective expulsion still holds, and I think in the discourse that's really important to hold on to, however concerning the judgment may be. Finally, MN and others versus Belgium. This is to do with a Syrian family who requested short-term humanitarian visas at the Belgian embassy in Beirut, so they could claim asylum upon entering Belgium. Their visas were refused, and the applicants brought proceedings before administrative courts and civil courts. At some point they were successful, but they did ultimately fail in their pursuit. They alleged a number of violations, including Article 3, in terms of that their refusal of the visa would expose them to a situation incompatible with Article 3. I think this is a really interesting topic at the moment when we have this discussion very much in the media in the UK about safe and legal means and safe and legal routes. In the end, these individuals did try legally, but they were refused. There were a number of state interveners in this case, and that's perhaps not surprising given how sort of highly charged an issue this is. In the end, a perhaps unsurprising outcome, although disappointing for those who advocate for the rights of refugees and asylum seekers. In the end, it all centred around jurisdiction, and we never got to the substance of the claim. There was held to be no jurisdiction, and there's you can go and read the case if you're interested more. There's a whole discussion about public powers, but also this unilateral entering of the Belgian court system, and the fact that these individuals were free to remove themselves from that, and that essentially didn't amount to an exercise of jurisdiction. Now, I think one paragraph which is particularly telling from the judgment said that on this conclusion, to conclude otherwise would imply a virtually universal application of the Convention. Now, one commentator has said that this case laid bare the naivety of believing in the universality of human rights in a world of disintegrating nation states. And we all have this idea and concept that human rights are universal, but we see that for refugees and asylum seekers who don't have the protection of the state that they're fleeing, and often don't fall within the jurisdiction of the state that they're asking to protect, do fall outside of that, and it does make us question this concept of universality, especially whenever jurisdiction really holds very firmly still. And so, what can we conclude about these cases? These are only 3 cases. There are more, but worth noting that all of them have come in the past 12 months, and there are more cases of significance to refugees and asylum seekers on the way, so it's definitely worth watching. So do we see promise or do we see peril? Is there this recent restrictive trend, or is there evidence of continued protective role of the Convention and the court? Well, I would say probably both. We've been through, the conditions in the transit zone not severe enough to trigger Article 3, decisions on deprivation of liberty and collective expulsion, all really quite concerning. But on the other side, we do see, the strong procedural obligation under Article 3, the holdings and jurisdiction, and actually the very existence of the Convention and the court as a means for redress for refugees and asylum seekers, and as a means of state accountability. I think we can't lose sight of that. So happy to continue the discussion further in the Q&A. I hope that that's given you sort of a brief overview of some of these cases that are emerging, and really what we can learn from them. So thank you very much for your time. I'll hand it back to you.